Hello, it's Philip Taylor speaking from Richmond Green Chambers. Today I'm looking at this book. It's come to us from Wildy, Simmonds and Hill Publishing. It's the Drug Drive Offences, a handbook for practitioners, now in a third edition by P M Callow. It's an important book, this one. It's not a big book in the sense it's not substantially overlong. There's 300 odd pages. The index at the back is by page numbering. It's an interesting and important work for you if you're involved in this area. There's the back of the book there. Then you've got various special reasons for non-disqualification. Probably the most important area actually for practitioners, because of that would be how you try to defend and get the most lenient sanction imposed, because obviously there are special circumstances, always are in these cases. There's the front page. And then you've got contents there, and then obviously runs through all the way through. Then after that you've got some cases. Then after that you've got there should be some statutes somewhere. Yes, there's some statutes. The usual statutes are there: Road Traffic Offenders Act, etc. Then you've got the statutory instruments, etc., codes of practice. And then some conventions. That's quite important this day and age. That's the European Convention on the Protection of Human Rights. Then there's a preface, well worth reading. Always read the preface because it tells you what's actually in the new book. And it's talking at the moment, this preface was written in January this year, and it talks about the aftermath of COVID. And then you've got the structure again. You've got paragraph numbering at the sides, and then you've got, in this case, basically no footnotes as such. There is a little bit, I think, but there's very little I saw because it's all actually in the body copy. You can see here, this is about blood and urine samples. You can see the various cases, all the details actually in the body copy itself. Now, what do I say about this book? Because it's been a while since I did prosecutions or defence work in this area, and obviously the disqualification and the loss and the special reasons are always very important, both for you as a student doing your actual examinations, because that's featured in the past, especially in things like the advocacy tests and so forth. But also it's important because this is a bread and butter area for practice for members of the junior bar, apart from anything else. What I say is this is an important updated statement for criminal practitioners in the developing area of offending in 2024, and that's exactly where we are. When I first started some 30 years ago at the bar, we didn't really have much in the way of drug driving offences, but that has substantially changed in recent years with a very large increase in the number of people taking drugs and a complete lack of any form of effectively sanction against it. And that's just the way society goes. No comment is made except to say that's where we are, but that shows that there's been a big increase, and therefore the law takes account of it. And the purpose of this book then is to bring together the statutory provisions and the case law on drink and drug driving offences, and obviously Wildy's offer us advice in what I think is an accessible, practical way. Again, it's their handbook series, and the author P M Callow describes the matter as elucidating issues which are often surprisingly difficult. Yeah, and they are sometimes, because you're looking at in terms of the sanction, a loss of a person's livelihood. Of course, that's an important area to bear in mind. Apart from the fact that the people who are being prosecuted are going to have problems of one sort and another because they've been taking alcohol, or they've been actually taking drugs and then driving. So therefore it's an important area to think about. Society, of course, also has its own view on those types of offences. So what we've got here with the second edition from Callow, it was updated from the 2018 edition for 2024, and the drug driving offences have come into their own in this time, as I've indicated, with the book adopting a neutral standpoint between the various interests of the police, prosecution and defence. That's helpful, bearing in mind the type of case you might get and whether you're prosecuting or defending, because there is still quite a switch between the two in chambers. I know that there are specialist chambers, but again, it's useful to look at it from both sides. I always do that, so I've got some idea, like mediation, of you say to your client, well, what do you think the other side's come here for? And looking at it that way does give you a refreshing view on where you're going. And as I say, this neutral standpoint I think is important, because the offences originally introduced in 2015 now account for almost as many convictions as the excess alcohol ones do. This is the drug one. So you can see the huge increase. And of course the conviction rate for both groups continues to be extremely high, around about 95%, because there isn't really much in the way of a defence. But what you've then got to look at is the problems behind the offence and what it's going to cause, what the difficulties are. And that in fact is probably the way we're going to be looking at some aspects of applied criminology in the future, because clearly with the huge numbers of people being imprisoned at the moment, we're going to have to look at some ways of trying to see how dealing with these people, there may be another way around it. Now the new third edition takes account of some 40 judgments of the appellate court since the publication of the second edition. And what the author says is this: the recent challenges to the drink and drug driving regimes have taken on a somewhat different character from before. So whilst the interpretation of the statutory road traffic provisions continues to be developed in our case law, other issues are coming to the fore with new cases. And precedent on the circumstances in which judicial review is appropriate has also been drawn together. And of course the line of developing cases often features contested decisions on adjournments, which can be crucial for the development of a case. And you know that many junior barristers, very junior barristers, are the ones who have to try and get the adjournments in the first case. And that can actually, it really is a baptism of fire sometimes. Now, common issues reviewed are lack of diligence in preparation for trial and or failure by the court below properly to scrutinise the application for an adjournment. That happens quite a lot actually, and there are a lot of reasons. I wouldn't be dare to blame name any people HMCTS for the problems, but we all know that there are a lot not of our own making. In fact, as I say, all the usual problems practitioners face are covered here, and I'm grateful to the author for doing that. Appeal courts, says Callow, have remained constant in insisting on rigorous scrutiny of requests for adjournments and have robustly applied the criminal procedure rules, aiming at avoiding delay. I understand that, because delay is always the defendant's friend in many ways. A lot of people obviously want to get these things out of the way as soon as they can. But sometimes you do need that extra time. I know I've needed it to make sure that you do the case properly. Now delay is, as I say, one of the biggest difficulties in the court system today. Obviously we've faced that for some time, and there have been no answers from any of the people who've been running in the last general election. The new Labour government may well come up with some interesting ways of dealing with it, but they certainly didn't mention it in the election, and neither did the Tories, so I don't know where we are at the moment. The thing is, we've still got those massive lists. In addition, with this book, judicial review has been increasingly used to challenge decisions of the lower courts. Again, there was at one stage a big discussion about the extent of judicial review of administrative action. Excuse me. But again, that seems to have fallen by the wayside recently. However, what we've got at the moment is case law on the circumstances in which this route is appropriate, which have been drawn together. And so what we've got is commentary on the difficult cases of the DPP and Callow, 2005, and this would be Regina versus Coe, 2009. Both have been reviewed to emphasise that neither case sets a precedent for the admission in evidence of the analysis of blood specimens taken outside the 1988 regime. Important point to bear in mind, because I'm afraid I have to say again that in criminal law you are getting down to really very, very clear nitpicking distinctions. It's one of these problems barristers do have, and that is to get your client off. Quite often you are really, in my view, some of them are scraping the bottom of the barrel, proverbially, the legal barrel, because they are making, I think, sometimes illogical distinctions, when at the end of the day we all know basically what the position is. However, that's the beauty of our judicial and our criminal justice system, and that is that you have to prove your case beyond a reasonable doubt. So let me conclude by saying it's right to say that this work remains a practical and accessible book. The author is always glad, he says, to hear from readers. I think it's a man. I don't know who actually Mr. Callow, if it is Mr. Callow, is, because I don't know the first name. But I'm taking it it's a man, but it may be a woman, I don't know. The author, anyway, is always glad to hear from readers about any comments to make or suggestions to offer concerning the content of the book. And as with all Wildy books, this one goes to the heart of our practice in an invaluable, and I think is an invaluable addition to your law library. Now, the date of publication is April 2024. Let's look at the book again. As I say, it's by P M Callow. I'm not quite sure who P M Callow is. It says P M Callow is the author of this book and co-author of the Handbook on Magistrates, but it doesn't say anything more about that particular person. So I don't know the first name of the person and virtually nothing anywhere. And it doesn't actually give any indication of whether it's, and I say this, whether it's a man or a woman, which is actually quite surprising, because when you get to the, certainly to the preface, again, all you've got are initials. You can see them at the bottom. So, and when I tried to Google, I couldn't find any information at all. This is very interesting, because we normally know who the people are. But that's beside the point. This is a really good book, and Callow is to be thanked. And as I say, I think one of the reasons, which I think people will find very helpful, is the special reasons for non-disqualification. Now, obviously there are arguments that are put forward and everything else. And I say that just as a tip for people who are doing the bar exams, because I certainly had to do an advocacy training exercise on special reasons for my qualification. And I suspect they still do that, because it's a very useful way of getting to see how you can develop the advocacy, and that you've also got a grasp of what are actually quite difficult issues. Anyway, there it is. That's the book. Thank you very much to P M Callow and to Wildy's for what is an excellent book. And thank you so much. You make our lives a lot easier by publishing these works. Good luck. Bye-bye.